Darren Coyle padlocked my access road, laid 4 commercial spike strips across my gravel, and posted a notice declaring my father's land an abandoned common corridor, all before 7 a.m. on a Saturday morning. He did it fast, clean, and with a laminated sign, the way a man does something he's been planning for a while. What he didn't know was that I'd been planning longer. I sat in my truck, engine off, coffee still warm. I read the notice through the windshield without getting out. HOA Resolution 2024-7, his signature at the bottom. Date, time, notary stamp, everything filed, everything recorded, everything permanent. That's the moment I knew this was over, not for me, for him. Because Darren Coyle had just walked onto land he had no legal authority over, installed physical obstructions, and signed his name to a document citing a resolution he passed without a quorum. And he did all of it believing I was the kind of person who would call the HOA office and ask politely to have my own property returned to me. He had spent 3 years reading me wrong. I pulled out my phone, started a time-stamped video, narrated the boundary markers, the chain, the padlock, the spike strips. One by one, slow and clear, the way you narrate something you intend to play in a courtroom. Then I drove home. Let him keep the chain up for another day. Because the question isn't whether I was angry. The question is, when you know someone is signing their own confession, do you stop them or do you hand them another pen? My name is Marcus Webb. I'm a real estate attorney in Phoenix, and I've spent 17 years reading documents that people signed without fully understanding what they were agreeing to. Deeds, CC&Rs, easement agreements, HOA resolutions. I read them the way a mechanic listens to an engine, not for what the document says it means, but for what it actually does. I say that not to brag. I say it because it's the only reason I recognized what Darren Coyle was doing long before he recognized it himself. I grew up out here in this part of Maricopa County when the nearest subdivision was a 20-minute drive and the land was mostly scrub brush, red dirt, and people who kept to themselves. My father, Raymond Webb, bought that half-acre parcel in 1987 for $11,000 cash, shook hands on a Tuesday, picked up the deed on a Friday, spent the following weekend pouring the first section of concrete floor himself, not as a contractor, not as an investor, but as a man who wanted a place where the weak couldn't follow him. He built the workshop cinder block by cinder block, restored vintage motorcycles, BSAs, early Triumphs, the occasional Indian Chief. He didn't sell them, didn't show them. He just liked the process of taking something broken and making it run again. He had a discipline about that work that I absorbed without knowing it. He never forced a part that didn't fit, never rushed a repair that needed time. He used to say, "The machine will tell you what it needs, if you stop trying to tell it what you want." He died in March of 2019, pancreatic cancer, 6 weeks from diagnosis to the end. He left me the parcel with one line in his own handwriting at the bottom of the will. "Keep the weather vane. It always knows where east is." I drove out the weekend after the funeral, sat inside for 2 hours. Didn't touch anything. Just let the light come through the west window the way it always had, and the smell of old motor oil and concrete dust do whatever it does to a person in a place like that. Then I locked the door and drove home. The Sunridge Palms HOA was incorporated in 2019. 47 homes on what had been a defunct nursery next door. Their CC&Rs were recorded with the county in January of that year. My father's parcel was not in the plat. It predated the HOA by 11 years. It was never annexed, never included, never subject to a single line of their governing documents. I confirmed this in 40 minutes of research, the first time a violation notice arrived in 2021. Pulled the plat, cross-referenced the parcel boundaries, wrote Darren Coyle a polite letter with the relevant documents attached. He sent another violation notice 3 weeks later. I wrote back again. Same documentation, cleaner language, less patience visible between the lines. He sent a third. By the time he padlocked my access road, the folder on my desktop labeled SRPOA contained 47 documents. I hadn't opened it in 2 months. I already knew exactly what was in it. I have a rule I've kept since my 2nd year of practice. Never respond to a bad faith move at the speed the other person wants you to. It sounds passive. It isn't. It's the opposite of passive. It requires more discipline than firing back immediately, because your instinct every time is to correct the record fast, loudly, in a way that makes absolutely clear you are not someone to be trifled with. That instinct feels like strength. In my experience, it's usually how people hand away their best leverage before they've had time to understand what they're holding. When Darren sent the first violation notice, I could have escalated immediately, filed a quiet title action, put the HOA on formal legal notice, made it expensive for them from day one. I had the standing, I had the documentation, I had the professional capacity to make his life genuinely difficult inside of a week. I didn't, because one violation notice, even a bad faith one, is just a notice. It tells you something about a person, but it doesn't tell you everything. I wanted to know what Darren Coyle did when someone pushed back calmly and correctly, whether he'd recognize the error and stop, or whether he'd do what people who've never been seriously checked tend to do, interpret the absence of a loud response as confirmation that they're winning. He sent a second notice, then a third. That's when I understood. This wasn't confusion. This wasn't an administrative oversight. This was a man who had been running an HOA unopposed for 4 years, who had developed an unshakable belief that the mechanism of the notice itself, the official letterhead, the resolution number, the implied threat of fines, was enough to make people comply. He'd probably used it successfully dozens of times. The retired couple in Unit 14 who repainted their shutters. The family in Unit 31 who moved their basketball hoop. It had always worked, so he kept using it the way people keep using tools that haven't broken yet, without stopping to ask whether the tool is appropriate for this particular job. What Darren never accounted for was the possibility that the person on the other end of those notices was reading them differently than his previous targets had. That instead of feeling intimidated, that person was building a file, dating every document, noting every procedural irregularity, watching the pattern solidify from possible mistake into something much more useful in a courtroom. A demonstrated course of conduct. There's a concept in property law called a pattern of interference. 1 incident is an incident. 2 incidents is a coincidence. 3 incidents, documented, dated, and consistent in their overreach, is a pattern, and a pattern is an argument. A strong one. By the time Darren Coyle put a padlock on my access road, he hadn't just committed one act of trespass. He had spent 2 years constructing the context that would make that trespass indefensible. He built the case against himself. I just kept the records. Have you ever watched someone confuse the silence of a patient person for the silence of a defeated one? Let me be specific about what was actually at stake here, because this wasn't a dispute about paint colors or gravel grades or a weather vane someone found aesthetically displeasing. Those were the pretexts. The actual stakes were different, and they were serious. My father's parcel is the last piece of pre-development land in that corridor. Half an acre of clear title, no HOA encumbrance, no CC&R restriction, no architectural review board with an opinion about what color I'm allowed to paint a cinder block wall. In a county where buildable land with clean title is increasingly difficult to find, that parcel is worth significantly more than the assessed value on the tax rolls, and everyone in real estate within 20 miles knows it. I had been approached twice in the past 3 years by developers with interest in the adjacent area. I declined both times. The parcel wasn't for sale. But the inquiries told me something important. Other people had done the math on what that land was worth unencumbered, and the number was not small. If Darren Coyle succeeded in establishing, even informally, even just through accumulated paperwork and community perception, that my parcel was subject to HOA authority, the practical effect would be corrosive. Future title searches would flag the violation history. Any attempt to sell, develop, or finance against the property would trigger questions about the HOA's claimed jurisdiction. Clearing that cloud from the title would require litigation regardless, but litigation after years of apparent acquiescence is a much harder argument than litigation after consistent, documented objection. In other words, every violation notice I failed to formally contest was a small brick in a wall Darren was building around my property, not a legal wall. Not a wall that would hold up in court if challenged directly and immediately, but a wall of paper, of recorded resolutions, of county filings that would complicate any future transaction and cost someone, probably me, probably whoever I eventually sold to, real money to dismantle. That's what was actually happening behind the language about paint standards and visual disruptions. And then he locked the road. The road is the only vehicle access to the workshop. Block that road, and the parcel becomes landlocked in practical terms, unreachable by any vehicle larger than what could navigate the surrounding desert scrub. Block it with commercial spike strips, and you're not just restricting access. You're actively threatening damage to any vehicle that attempts entry. This was no longer about aesthetics. This was about control of land my father bought before Darren Coyle ever set foot in this county. The third violation notice was the one that changed how I was paying attention. Not because it was more threatening than the first two. It wasn't. Same letterhead, same resolution citations, same demand that I bring the parcel into compliance with community standards that had no legal authority over my parcel. What changed was a single line near the bottom that hadn't appeared in the previous two notices. Continued non-compliance may result in HOA-initiated remediation at property owner's expense. I read that line 3 times. Then I opened a new folder on my desktop, labeled it SRPAA, and started pulling public records. Not because I was panicking, because that line told me something had shifted in Darren Coyle's thinking. The first two notices had the texture of bureaucratic habit, the kind of thing an HOA president sends because sending notices is what HOA presidents do, and because most people fold after the second one. But remediation at property owner's expense was a different category of threat. That was language borrowed from municipal code enforcement. That was the language of a man who had started to believe he had actual governmental authority over my land. That belief was dangerous. Not because it was legally supportable. It wasn't, not even slightly, but because a man who believes he has authority tends to act like he has authority. And action, even wrongful action, creates facts on the ground that have to be unwound. So, I started pulling. Arizona HOA law requires board members to be current on their assessments to hold office. It's not a gray area. It's black-letter statute, and it's mirrored in Sunridge Palms' own bylaws, which I downloaded from the county recorder's public portal in about 4 minutes. I cross-referenced the HOA's lien filing history, also public record, and found something that made me sit back in my chair. Darren Coyle was 11 months delinquent on his own HOA assessments. The man enforcing community standards against my parcel, a parcel he had no jurisdiction over, was himself in violation of the most basic financial obligation of HOA membership. And under both Arizona statute and his own organization's governing documents, that delinquency disqualified him from holding board office. He was, in the precise legal sense of the word, illegitimate. I kept pulling. The HOA's financial records showed assessment collections from my parcel going back to 2021, the same year the first violation notice arrived. They had been billing me for dues on a property they had no authority over, and someone, presumably Darren, had been recording those payments as legitimate HOA revenue. That was unjust enrichment. That was a separate cause of action entirely. I didn't call anyone, didn't send a letter, didn't update my response to the third violation notice beyond my standard documentation citation. I just kept the folder open and kept adding to it. Have you ever noticed that the people most certain they can't be checked are usually the ones who forgot to check themselves first? 4 months before the padlock, Darren Coyle called me directly for the first time. It was a Tuesday evening. I was reviewing a title commitment for a client when my cell rang. Unknown number, Arizona area code. I almost let it go to voicemail. Something made me answer, Mr. Webb. His voice had the particular texture of a man who had rehearsed the opening line. Confident, controlled, with just enough warmth layered on top to suggest he was doing me a favor by calling personally. This is Darren Coyle, president of the Sunridge Palms HOA. I think it's time we had a direct conversation about your property situation. I let a beat pass before I responded. I'm listening. He laid it out the way a regional sales director would, framing everything as mutual benefit, community cohesion, property values for everyone involved. He said the board had discussed my parcel at length. He said there were options available to me if I wanted to work cooperatively toward resolution. He used the word resolution 4 times in 3 minutes, which in my experience means the person using it has already decided what the resolution is going to be. Then he said it. The simplest path forward would be for you to voluntarily bring the property under the HOA's umbrella. We can waive the outstanding violation fines as a show of good faith. You'd have full access to community amenities, and we'd have the consistency the neighborhood needs. I wrote down the time. 7:22 p.m. I wrote down voluntary annexation offer, fines waiver conditional. Then I said very calmly, Darren, I've sent you documentation 3 times showing that parcel has no legal connection to Sunridge Palms. That hasn't changed. I'd encourage you to have your HOA's attorney review the original subdivision plat before the board takes any further action. Silence. The kind that comes from a man recalibrating. I understand your position, he said finally, but the board has the authority to. It doesn't, I said, not loudly, just clearly. I'm telling you directly, and I'm telling you now, so that later there's no question about whether you were informed. That parcel predates your HOA by 11 years. It was never included in the plat, and any action your board takes against it will be taken without legal authority. I'd stop here if I were you. He thanked me for my time with the smoothness of a man who had already stopped listening. We hung up. I made a note in the SRPOA folder. Titled it, Direct Warning, Verbal, 7:22 p.m., Coyle acknowledged position and continued. I didn't follow up with a letter that week. I considered it, and then I didn't. Because I realized something important during that phone call. Darren Coyle wasn't going to stop based on a warning. He was going to stop when stopping was the only option he had left. So I waited, and I kept the folder open. If someone tells you clearly that the ground beneath you won't hold, and you keep walking anyway, at what point does the fall stop being an accident? 3 weeks after that phone call, the HOA newsletter went out to all 47 households in Sunridge Palms. I wasn't on the mailing list. A resident forwarded it to me, someone who had seen the violation notices on county records and put 2 and 2 together. She didn't identify herself beyond a first name. She just scanned the relevant section and sent it without comment. The newsletter dedicated half a page to what Darren called the ongoing remediation effort regarding the non-conforming parcel adjacent to our eastern boundary. He described the parcel as an eyesore affecting community property values. He used the phrase unauthorized structure twice. He told residents the board was pursuing all available compliance mechanisms and expected resolution before the end of the quarter. He did not mention that the parcel predated the HOA by 11 years. He did not mention that he had no legal authority over it. He did not mention that the owner had informed him of both facts, in writing, 3 times, and verbally once. What he did was create 47 potential witnesses to a public misrepresentation. He put it in writing, distributed it, and kept a copy on file, because HOA newsletters under Arizona law are organizational records subject to member inspection. I saved the scan, added it to the folder, labeled it, Public Misrepresentation, distributed to full membership, dated. Then I noted something else. The newsletter listed Darren Coyle's name and title at the bottom. Darren Coyle, Board President, Sunridge Palms HOA. Standard, routine. Except that by the date on that newsletter, his assessment delinquency had crossed the 12-month threshold, the specific trigger under Arizona Revised Statutes Section 33-143 that rendered a board member ineligible to continue serving. He was signing official HOA communications as board president at a time when he was legally disqualified from the position. Every document he produced from that point forward carried that flaw. Every resolution, every notice, every newsletter. All of it signed by a man who, under the law that governed his own organization, had no authority to sign anything. The trap wasn't something I built. I just watched him furnish it, piece by piece, and kept the receipts. How much rope does a man need before you stop worrying about whether he has enough? The week after the newsletter, I stopped being purely reactive, not loudly. Nothing that would signal to Darren that the temperature had changed. From the outside, I was still the same quiet property owner who sent politely worded letters and didn't show up to HOA meetings. But internally, the posture shifted. I wasn't just keeping records anymore. I was building a case file with a specific destination in mind. First, I pulled every HOA board meeting minute from 2020 through the present, all public record, available through the county recorder's portal. I went through them line by line. What I was looking for was quorum documentation. The HOA's own bylaws required a minimum of 3 board members present for any resolution to pass. Sunridge Palms had 5 board positions, 3 was the floor. I found what I was looking for in the minutes from the meeting where Resolution 2024-7 was passed. The resolution Darren had zip-tied to my access road chain. The attendance log listed 2 board members present, plus Darren, 3 total. Quorum met technically on paper, except one of the 2 listed members, I'll call her the treasurer, had sent a written notice of absence to the board secretary 4 days before the meeting. That notice was in the HOA's own filed records, which meant the actual attendance at that meeting was 2, Darren, and 1 other member. No quorum. Resolution 2024-07 was void from the moment it was passed. He had padlocked my road and laid spike strips across my gravel, citing a resolution that had no legal existence. I didn't file anything that week. I called a colleague who specializes in emergency injunctive relief and walked her through the file in about 40 minutes. She asked me one question at the end. How physical did it get? I told her about the spike strips. Commercial grade, professionally installed, the kind that shred tires at low speed. She was quiet for a moment. That's not a paperwork problem anymore, she said. That's conversion and potential vehicle damage. That's injunctive territory. I told her I knew. I told her I wanted to wait until I had the full chain documented. The notices, the phone call, the newsletter, the quorum failure, the delinquency, the improper dues collection. All of it in sequence, all of it sourced to Darren's own filings. You want the whole rope in one exhibit, she said. I want the whole rope in one exhibit, I confirmed. She told me to call her the moment he did something physical again. I told her I didn't think I'd be waiting long. I didn't have to wait long. 9 days after I spoke with my colleague, I drove out to the workshop on a Wednesday afternoon to check on a slow leak in the roof flashing I'd been meaning to address. I turned onto the access road and found the chain still up. Darren hadn't removed it after the Saturday morning installation, which meant it had been blocking my access for over a week. And next to it, a second sign that hadn't been there before. This one was larger, printed on weather-resistant stock, zip-tied to a T-post driven into the ground at the road's edge. It read, Sunridge Palms HOA common property, no unauthorized access, violators subject to towing at owner's expense. He had escalated. Not content with blocking the road, he had now publicly rebranded my access corridor as HOA common property, in writing, on a sign visible from the county road, with a towing threat attached. I photographed the sign from 6 angles. Photographed the T-post, the ground disturbance where it had been driven in, the zip ties, the lamination. Narrated another time-stamped video, noted the GPS coordinates. Then I drove to the county assessor's office and pulled the current parcel boundary map for the corridor, the physical document, stamped and certified, and had it copied on the spot. The access corridor was not HOA common property. It was not on any HOA plat. It was not owned, managed, or maintained by Sunridge Palms in any recorded capacity. The sign was not an overreach. It was a fabrication. A physical, publicly visible, county road-facing fabrication installed on ground that did not belong to the HOA, making a claim that had no basis in any recorded document. And Darren had done it in a way that any passing driver, any neighbor, any future title searcher, pulling aerial records could see. I sat in the assessor's parking lot with the copied plat on my passenger seat and added 4 new items to the case file: the sign photos, the time-stamped video, the GPS log, and the certified parcel map. Then I called my colleague. He put up a towing sign, I told her, on my access corridor. Called it HOA common property, a pause. Then he just handed you defamation of title. I know, I said. I've got the plat copy in my hand. 2 days after the towing sign went up, Darren Coyle held a community information session. I found out about it the same way I'd found out about the newsletter. The same resident, first name only, forwarded me the meeting notice with no comment beyond. Thought you should see this. The session was held on a Friday evening in the Sunridge Palms clubhouse. Attendance was optional but strongly encouraged, per the notice which described the agenda as an update on community boundary integrity and the eastern parcel remediation effort. Darren had reserved 90 minutes. I wasn't invited, I wasn't a member. But the clubhouse had floor-to-ceiling windows facing the parking lot, and one of the attending residents, a retired schoolteacher named Gerald, who had introduced himself to me once at the county recorder's office while we were both pulling documents, texted me a photograph 40 minutes into the session. It showed Darren standing at the front of the room in front of a printed display board. On the board was an enlarged aerial map of the area with my parcel outlined in red marker. The caption at the top of the board, visible even in a low-resolution phone photo, read, "Unauthorized non-conforming use, active remediation." Gerald's text beneath the photo said only, "He's telling people the property is abandoned, and the HOA is reclaiming it for community use." I read that twice. Then I called Gerald and asked him to stay until the end and remember everything he could. What Gerald reported afterward was more useful than anything I could have scripted. Darren had told the assembled residents, approximately 30 of them, Gerald estimated, that the parcel's owner had been unresponsive to repeated good faith outreach, that the HOA had exhausted all cooperative options, that Resolution 2024-07 authorized the board to secure and remediate the corridor for community safety. Then he said the line that Gerald quoted back to me verbatim, slowly, the way you quote something because you know it matters. I have full authority to handle this. Nobody is going to stop us from protecting this community. Full authority. Nobody going to stop us. 30 witnesses, a display board, a printed aerial map with my parcel outlined in red. I asked Gerald if he'd be willing to write down what he remembered while it was still fresh. He said he already had. He emailed me 4 pages of handwritten notes, scanned, timestamped by his email server, before I went to bed that night. 30 witnesses, a false public statement, a declaration of unchecked authority. He hadn't just overreached. He had performed the overreach for an audience. Does a man become more dangerous when he has a room full of people nodding along? Or is that exactly the moment he stops being careful? The following Monday, Darren moved from words to infrastructure. A landscaping crew showed up at 8 a.m. with a flatbed truck and a skid steer. I know this because Gerald texted me a photo at 8:17, and because the crew's truck had a Magnetic Company logo on the door, a local outfit called Desert Edge Property Services, that I was able to identify from the image in about 90 seconds. They spent the morning grading the shoulder of my access corridor, not clearing brush, not maintaining anything, grading, reshaping the ground profile along the corridor's edge in a way that would make it significantly harder for a vehicle to bypass the chain by going around it. They also installed 2 additional T-posts and strung orange construction fencing along a 40-foot stretch of the corridor boundary. By noon, my access road looked to any casual observer like an active HOA maintenance project. I called Desert Edge Property Services at 12:30, asked to speak with the owner. Got a project manager instead, a man named Troy, who was polite and clearly had no idea he was about to have a difficult afternoon. I asked him who had authorized the work order. He told me it was an HOA contract, standard maintenance signed by the board president. I asked him if he had a copy of the work order he could read to me. He did. He read it. The work order cited Resolution 2024-07 as the authorizing document and described the scope as corridor securing and boundary remediation per board directive. Darren Coyle's signature, HOA letterhead, date, and project number. I thanked Troy, told him I was the parcel owner, told him the work was being performed without legal authority on a corridor that was not HOA property, and strongly advised him to pause operations until he'd spoken with his own company's attorney. I gave him my name, my bar number, and my direct line. Troy called back 43 minutes later and told me the crew had stopped work. Desert Edge, to their credit, pulled out the same afternoon. But the grading had already been done. The fencing was already up. The work order, signed, dated, project numbered, citing the void resolution, was already in existence. Troy emailed me a copy at my request, noting that Desert Edge was preserving it for their own records given the circumstances. That work order became Exhibit G in my TRO filing, but Darren wasn't finished. That same evening, he sent a certified letter to my address of record, the first certified communication he had ever sent, which itself told me something about his confidence level, informing me that the HOA had engaged legal counsel to pursue formal adverse possession proceedings against the parcel if remediation efforts continued to be obstructed. Adverse possession. In Arizona, adverse possession requires open, continuous, hostile, and exclusive use of a property for 10 years under a claim of right. My father had owned and used that parcel continuously since 1987. The HOA had existed for 5 years. The legal theory Darren was threatening me with was not just wrong, it was inverted. He was describing, with precise legal terminology, the exact claim I had against any encroachment on my land and presenting it as a weapon pointed at me. I read the letter twice, added it to the folder, labeled it, certified letter, adverse possession threat, legally inverted, counsel engaged. Then I called my colleague and told her the file was complete. Everything? She asked. Everything, I said. 2 years of notices, the phone call, the newsletter, the community meeting, the work order, the towing sign, the quorum failure, the delinquency, the improper dues, and now a certified legal threat citing a doctrine that runs in my favor. She was quiet for a moment. He built you a complete record, she said. He did, I said. Every piece of it in his own handwriting. There was a woman on the Sunridge Palms board named Patricia Shu. She was the secretary, had been since 2021. A quiet presence in the meeting minutes. Her name appeared on attendance logs, her initials on document certifications, her signature on correspondence that went out under the board's collective authority. From the records, she seemed like the kind of person who showed up, did the administrative work, and didn't make waves. Gerald mentioned her after the community information session. Said she'd sat at the end of the front row and hadn't said a word the entire 90 minutes. Said she'd left quickly afterward, before most of the residents. Said she'd had an expression on her face that he described, after a pause, as the look of someone watching a car drive toward a wall and not being able to do anything about it. I filed that away. 3 days after the landscaping crew left, I received an unsigned envelope at my office address. Inside was a single sheet of paper, a printout of an internal HOA email thread dated 6 weeks earlier between Darren and the 2 other active board members. The treasurer had replied to one of Darren's directives about the corridor remediation plan with a 3-line response. I want to flag that I'm not comfortable with this course of action without a legal opinion. I think we should pause until we've had outside counsel review our authority over the parcel. Darren's reply 4 minutes later was 1 sentence. Already handled. Moving forward. The treasurer's name was copied on every subsequent communication. She had raised the concern. She had been overridden. And she had continued to sign documents under the board's authority for 6 more weeks, right up to and including the certified letter. I don't know who sent me that envelope. I have a reasonable guess. What I do know is that it added a dimension to the record that I hadn't had before. Internal dissent, documented, time-stamped, showing that at least 1 board member had flagged the legal exposure and been dismissed. That mattered not just for the case, but for what came after. Because when the membership eventually saw the full picture, they would need to understand that this wasn't a collective failure. It was one man overriding the people around him, repeatedly, in writing, because he was certain that certainty was enough. Patricia Hsu resigned from the board 4 days after the TRO was granted. She sent a 1-paragraph letter to the membership. She didn't explain much. She didn't have to. How many people stay quiet not because they agree, but because they've already learned that speaking up changes nothing, until suddenly it changes everything. The certified letter changed the timeline. Until that point, I had been moving deliberately, pulling records, building the file, waiting for the pattern to complete itself. I had the luxury of patience because Darren's actions, while damaging, had not yet created consequences that couldn't be reversed. A chain across a road can be removed. A towing sign can be taken down. Grading work is annoying, but not permanent. The adverse possession threat was different. Not because it had legal merit. It didn't. And any first-year property law student could have explained why. But because Darren had now stated, in a certified letter, that he had engaged legal counsel to pursue formal proceedings, if that counsel filed anything, even a frivolous filing, even something destined to be dismissed, it would attach to my title record. It would show up in future searches. It would require a formal legal response to clear. And the longer I waited to establish the definitive record of my ownership and the HOA's lack of authority, the more expensive and complicated that clearing process became. My colleague had used a phrase I kept returning to, clouds on title. A cloud on title is anything in the public record that creates uncertainty about ownership, a lien, an unresolved claim, a lis pendens. Clouds don't have to be valid to do damage. They just have to exist long enough for someone to find them at the wrong moment. Darren was trying to manufacture a cloud, and if his attorney filed anything before I moved, I'd be spending the next 18 months clearing it instead of litigating it. I called my colleague on a Thursday morning, told her I was ready. She said she'd have the TRO application drafted by end-of-day Friday. I spent Thursday afternoon pulling the final version of every document in the folder, organizing them into a single numbered exhibit list, and writing the factual chronology that would accompany the filing. 47 exhibits, spanning 26 months. Every violation notice, every letter, every email, the phone call log, the newsletter scan, Gerald's 4 pages of handwritten notes, the work order from Desert Edge, the certified letter, the quorum attendance discrepancy, the assessment delinquency records, the improper dues collection history, the towing sign photographs with GPS coordinates, the certified parcel boundary map. I worked until 2 a.m. that night at my kitchen table with the file spread across every available surface, not frantically, methodically. The way you pack a case when you know exactly what's in it and exactly where each piece needs to go. At some point after midnight, I made coffee and stood at the kitchen window for a few minutes. Thought about my father pouring that concrete floor on a weekend in 1987. Thought about the weather vane. Thought about the particular satisfaction of a repair done correctly, where every part fits exactly as it should, and the machine runs the way it was always supposed to run. By Friday afternoon, the filing was ready. What's the difference between patience and paralysis? One of them ends with a complete case. The other just ends. The exhibit that closed the file wasn't the one I expected. I had built the case around 7 core elements: the jurisdictional defect, the quorum failure, the trespass, the conversion, the defamation of title, the unjust enrichment, and the delinquency disqualification. Each one was independently actionable. Together they were overwhelming. I was confident in the filing before I found what I'm about to describe. What I found was in the HOA's financial records, specifically in a line item buried in the 2023 annual budget summary, a document Darren had filed with the county recorder in February of that year as part of the HOA's routine annual disclosure obligations. The line item read, Eastern Corridor Acquisition Reserve, $14,200. I stared at that line for a long time. An acquisition reserve is exactly what it sounds like. It's money set aside for the purpose of acquiring something, not maintaining something already owned, not remediating something within existing authority. Acquiring, which meant that somewhere in Darren Coyle's planning, he had acknowledged, in a document filed with the county, under his signature, as a formal financial disclosure, that the Eastern Corridor was not currently HOA property. You don't create an acquisition reserve for something you already own. You create it for something you intend to obtain. He had been publicly claiming my parcel as HOA common property, threatening adverse possession proceedings, installing infrastructure and signage asserting HOA ownership, while simultaneously maintaining a budget line that proved he knew the parcel wasn't his to claim. In a single line item, he had contradicted every public statement he had made about the corridor for 2 years. He had done it in a formal financial disclosure. He had signed it. He had filed it with the county. And it had been sitting in the public record the entire time, waiting for someone to read the budget closely enough to find it. I called my colleague at 11 p.m. and read her the line item over the phone. She didn't say anything for about 4 seconds. Then, he budgeted to steal it. He budgeted to acquire it, I said, while telling his residents he already owned it, while threatening me with adverse possession, while filing resolutions asserting HOA authority over it. That's fraud on the membership, she said. That's a separate exposure entirely. I added it to the exhibit list, labeled it Exhibit 44, 2023 Annual Budget Summary, Eastern Corridor Acquisition Reserve, $14,200, filed County Recorder, February 2023, Coyle signature. Then I sat back and looked at the full exhibit list one more time. 47 items. 2 years and 3 months of Darren Coyle's own documentation, his own signatures, his own filings, his own words in his own handwriting, arranged in chronological order, each one following logically from the last, each one making the next one worse. He hadn't just overreached. He had constructed a paper architecture of overreach so thorough, so well documented, so carefully filed with the appropriate county offices that dismantling his position required nothing more than reading his own records back to him in the correct sequence. The trap had exactly one architect, and he had been building it for 26 months, one signed document at a time, when the evidence against someone was written entirely in their own hand. Does that count as justice or just arithmetic? We filed on a Monday morning. By Monday afternoon, Darren Coyle's attorney had filed a response. I hadn't expected that. Not the speed of it. Good attorneys move fast when they need to, but the substance. Because what Darren's attorney filed wasn't a motion to dismiss or a request for additional time. It was a counter-application, an aggressive one. It requested that the court deny my TRO, affirm HOA authority over the corridor under a theory of implied dedication, and, this is the part that made my colleague go very quiet when she called me, sought an immediate injunction preventing me from accessing or interfering with what the filing described as HOA-managed common space currently undergoing authorized remediation. Implied dedication, it's a real legal doctrine. It holds that a private landowner can, through years of allowing public or community use of their property, implicitly dedicate that property to public or community use even without a formal recorded instrument. It's a legitimate theory. It's also extraordinarily difficult to establish, requires a substantial evidentiary record, and has a very specific set of requirements under Arizona law that I knew, and that Darren's attorney apparently believed he could meet. The argument, stripped to its core, was this. My father and I had allowed the corridor to exist adjacent to the HOA development for years without formal objection, and that passive adjacency constituted implied community dedication. It was wrong, legally, factually, procedurally wrong. But it was the kind of wrong that sounds plausible to a non-specialist, and it was the kind of wrong that, if a judge gave it even provisional credence, could result in my TRO being denied pending a full evidentiary hearing, which could take months. The judge did not grant Darren's counter-application, but she did schedule an expedited hearing for Wednesday 2 days out, rather than ruling on my TRO application immediately. 2 days, with the chain still on my road, with the spike strip still on my gravel, with the towing sign still visible from the county road, publicly declaring my father's land to be HOA common property. Gerald texted me Tuesday evening, said Darren had called another community meeting that afternoon, unscheduled, to tell residents that the HOA's legal team had successfully delayed the property owner's attempt to interfere with remediation. Said Darren had used the word victory twice. Said the room had applauded. I read that text standing in my kitchen and felt something I had been carefully managing for 2 years move closer to the surface than I usually allow. Not rage, something quieter and colder than rage. The particular feeling of watching a wrong thing be celebrated by people who don't yet know it's wrong, and knowing that in 48 hours they would. I went back to my desk, spent Tuesday night preparing for the Wednesday hearing with the kind of focus that only comes when you have no margin for anything less. Reorganized the exhibit sequence, sharpened the chronology, prepared a 1-page timeline that laid out every action Darren had taken, every date, every document number, every filing, in a single visual sequence that any judge could follow in under 4 minutes. Then I found the budget line item again. Eastern Corridor Acquisition Reserve, $14,200. Looked at it for a moment, printed it separately, put it at the top of the exhibit stack, because that was the piece I was going to put in front of the judge first. Not the trespass, not the spike strips, not the quorum failure, the budget line, the one where Darren Coyle, in his own handwriting in a document he filed himself, told the county exactly what he knew and exactly what he was planning, while telling everyone else something entirely different. Let him explain that one first. What does it feel like to watch someone celebrate winning a battle they've already lost? And know you're the only one in the room who's read the ending. I want to tell you something about that Wednesday morning before the hearing. I woke up at 5 a.m. Not from anxiety. I just woke up. The way you wake up when something has been building long enough that your body knows today is the day before your mind catches up. I made coffee, stood at the kitchen window in the dark, and I thought about my father. Not about the parcel specifically, not about the legal strategy or the exhibit stack or the budget line item. I thought about a specific Saturday morning when I was 11 years old and I'd gone out to the workshop and found him sitting on an overturned milk crate, completely still, staring at a BSA engine he'd been rebuilding for 3 months. I asked him what was wrong. He said nothing was wrong. He said sometimes you have to sit with a thing long enough to understand what it's actually asking you to do, and that most people skip that part because sitting still feels like not working. I thought about that a lot over the past 2 years. The sitting still part, because here is the honest truth about what it cost to do this the way I did it. It wasn't free. For 14 months, I drove past a padlocked road and a towing sign that called my father's land someone else's property. I received certified letters threatening legal proceedings against a parcel my father bought for cash in 1987. I watched a man stand in front of 30 of his neighbors with an aerial map and my property outlined in red and tell them he had full authority to take it. I sat with all of that, didn't move, didn't fire back, kept the folder open and kept adding to it. There were nights when the patience felt less like strategy and more like something I was inflicting on myself. When I thought about calling Darren back and telling him exactly what I had and watching him understand what he'd done. When the restraint felt indistinguishable from powerlessness. But I kept coming back to what my father said about the engine, sitting with it, understanding what it's actually asking. What this situation was asking was not for a loud response. It was not asking for the satisfaction of an early confrontation. It was asking for the complete record, the full chain. Every link forged by Darren's own hand, in sequence, unbroken. Anything less would have given him room to reframe, room to negotiate, room to walk back one piece and claim the rest was misunderstanding. I didn't want to win one piece. I wanted the whole thing closed. The hearing was at 10 a.m. in Maricopa County Superior Court, Courtroom 7B. My colleague presented. I sat at council table with the exhibit stack in front of me, organized exactly as I had arranged it the night before, and I watched Darren Coyle sit 12 feet away with his attorney and wait for what he still believed was going to be a procedural skirmish he could survive. He was wearing a blazer. He had a legal pad. He looked, to anyone watching, like a man who had done this before and wasn't worried. My colleague opened with the budget line. Not the trespass, not the spike strips, not the 2 years of violation notices. She put Exhibit 44 on the screen first, the 2023 Annual Budget Summary, Eastern Corridor Acquisition Reserve, $14,200, and she let the judge read it without commentary for a full 10 seconds. Then she said, "Your Honor, this document was filed by the respondent with the Maricopa County Recorder in February of 2023. It is the HOA's own formal financial disclosure. It contains a budget line item reserving funds for the acquisition of the Eastern Corridor. We begin here because this single document establishes in the respondent's own hand, filed in the respondent's own name, that as of February 2023, the respondent knew the Eastern Corridor was not HOA property. Everything that follows in our exhibit sequence occurred after this filing. Every public claim of HOA ownership, every resolution, every notice, every sign, every certified letter. All of it came after this document, and all of it contradicts it." Darren's attorney objected. The judge overruled him and asked my colleague to continue. She walked the chronology in sequence. 11 minutes, start to finish. She did not editorialize. She did not characterize. She read the record. Exhibit 1 through 6, the violation notices, each one citing HOA authority over a parcel the HOA's own budget acknowledged it did not own. Each one sent after my written response citing the jurisdictional defect. Each one demonstrating that the respondent had been informed and had continued. Exhibit 7, my documented response to the third notice, with the specific language advising Darren to consult counsel before proceeding. Sent, acknowledged, ignored. Exhibit 12, the phone call log, date, time, duration, summary, the verbal warning, the direct statement that the parcel predated the HOA and was not subject to its authority. Darren's acknowledgement and continuation. Exhibit 19, the HOA newsletter, distributed to 47 households, describing my parcel as an unauthorized structure undergoing active remediation. Public misrepresentation, distributed in writing, retained as an organizational record. Exhibit 23. The quorum attendance records for the meeting at which Resolution 2024-07 was passed. The board secretary's written notice of absence filed 4 days prior. Actual attendance, 2 members, quorum requirement 3. Resolution 2024-7 void ab initio from the moment of its passage. Exhibit 27, the Arizona Revised Statutes section and the HOA's own bylaw provision disqualifying delinquent members from board office. Exhibit 28, the HOA's lien filing history showing Darren Coyle's assessment delinquency crossing the 12-month threshold in the same month he signed Resolution 2024-07. Every document he signed after that date, every notice, every resolution, every certified letter, signed by a man legally disqualified from the position he was signing from. Exhibit 31, the towing sign photographs with GPS coordinates and timestamp. The certified parcel boundary map showing the corridor was not HOA property, side by side. The sign claiming what the map disproved. Exhibit 35. Gerald's 4 pages of handwritten notes from the community information session. Darren's statements to 30 residents that the parcel was abandoned, that the HOA was reclaiming it for community use, that he had full authority and nobody was going to stop them. 30 witnesses, a display board, an aerial map with my parcel in red. Exhibit 38, the Desert Edge Property Services work order, signed by Darren, citing the void resolution, authorizing physical modification of a corridor the HOA had no authority over, performed, billed, paid from HOA funds. Exhibit 41, the HOA's assessment collection records showing dues billed and collected from my parcel from 2021 through the present. A parcel the HOA had no authority over, 3 years of collections. Unjust enrichment under Arizona statute calculated with interest. Exhibit 44, back to the budget line, the acquisition reserve, the document that proved he knew. And finally, Exhibit 47, the certified letter threatening adverse possession proceedings. My colleague read the relevant Arizona statute on adverse possession aloud. Requirement, 10 years of open, continuous, hostile, exclusive use under a claim of right. The HOA had existed for 5 years. My father had owned the parcel for 32. She set the letter down without further comment. The courtroom was quiet. The judge looked at the exhibit stack for a moment. Then she looked at Darren's attorney and asked him to respond to the quorum deficiency in Resolution 2024-07. His attorney said the attendance records were subject to interpretation, that the absent board member's written notice might not have been formally received, that there were procedural questions about how the absence was recorded. The judge asked him if he had the original notice of absence. He said he would need to review the HOA's records. The judge said, "Counsel, that document is Exhibit 23 in the petitioner's filing. It was pulled from your client's own county-recorded organizational records. Do you have a substantive response to its content?" A pause. A conference at the defense table, quiet enough that I couldn't hear it. Then, we would request additional time to review the full exhibit set. The judge granted the TRO. She voided Resolution 2024-07 on the record. She ordered the immediate removal of all physical obstructions from the access corridor. She scheduled a full evidentiary hearing for 30 days out on the remaining causes of action and noted for the record that the petitioner's documentary evidence appeared comprehensive and that the respondent would benefit from thorough preparation. That last line was the judicial equivalent of a raised eyebrow. My colleague gathered her materials. I looked across the room at Darren Coyle. He was staring at the exhibit stack, not at me. At the paper, his own signatures, his own filings, arranged in the order that made them impossible to explain away. I thought about something he had said to 30 residents 6 days earlier, with a display board behind him and a room full of applause. "I have full authority to handle this. Nobody is going to stop us." He had been right about one thing. Nobody had stopped him. Not once, not anywhere along the line, had I stepped in front of him and blocked what he was doing. I had let him do every single thing he wanted to do. I had just made sure he did it on the record. You don't always need to stop someone who's building a case against themselves. Sometimes the most powerful thing you can do is hold the door open and let them finish. On a Tuesday afternoon, 6 days after the hearing, I drove out to the workshop with a sheriff's deputy beside me. The contractor was already there when we arrived, a different crew from Desert Edge hired by the HOA under court order. 2 men with bolt cutters and a flatbed. They worked quietly, cut the padlock first, coiled the chain, then lifted the spike strips one by one from my father's gravel and loaded them onto the truck. The towing sign came down last. The T-post pulled from the ground with a single wrench and a sound like something finally giving way. Darren sat in his car at the far end of the road and watched. He didn't get out, didn't say anything, just sat there behind the windshield while his own hired contractor dismantled everything he'd spent 14 months building. I didn't say anything either. There was nothing left to say that the paperwork hadn't already said better. The full resolution came in stages over the following 6 weeks. The civil settlement covered my legal fees in full, the assessed damage to my access corridor, and 3 years of improperly collected HOA dues with statutory interest, a number that surprised even me when the final calculation came in. The Eastern Corridor Acquisition Reserve line item was removed from the HOA budget at an emergency board session, and the $14,200 returned to the general fund with a formal notation in the minutes. The membership vote on Darren's removal was held on a Thursday evening. 28 votes to remove, 1 against. The one was Darren. Patricia Shue did not vote. She had already resigned. But Gerald told me she was there that night, sitting in the back row, and that when the final count was announced, she gathered her things and left without expression. The way a person leaves a room where something difficult has finally, correctly, ended. I drove out to the workshop the weekend after the vote, unlocked the door for the first time in over a year, stood inside for a while, the way I had the weekend after my father's funeral, let the light come through the west window, let the smell of concrete and old motor oil do what it does. The weather vane was still on the roof, still pointing east. It has pointed east through 38 Arizona summers, through my father's hands and mine, through a chain and a padlock and a laminated notice and 47 exhibits, and one Tuesday afternoon with a bolt cutter and a deputy and a man sitting in a car who finally ran out of paper. It will keep pointing east. Here's what I want to leave you with. Darren Coyle didn't lose because I was smarter than him. He lost because he was so certain of his own authority that he documented everything. Every overreach, every false claim, every signature on every resolution he had no right to pass. All of it filed, recorded, timestamped, and waiting. He built the record that buried him, one careful, confident page at a time. Your documentation is your property line. Know it before someone else decides they do. And if someone ever tells you that staying quiet means you're losing, ask yourself, losing or loading?
But here's what this story was really about. It was never about a padlock. It was never about a chain across a gravel road or a laminated sign or a resolution number on HOA letterhead. It was about what happens when a person acquires just enough authority to stop distinguishing between enforcing rules and owning people. Darren Coyle didn't start as a villain. He probably started as someone who genuinely believed in community standards, someone who liked things orderly, someone who found, over time, that the mechanism worked, that sending a notice made people comply, that the letterhead carried weight, that most people would rather fold than fight. And every time it worked, the belief calcified a little more, that the authority was real, that the silence meant agreement, that nobody was actually counting. He stopped asking whether he had the right. He assumed it. That's not a rare personality. Most people have encountered one. Maybe not in an HOA. Maybe in a workplace, a church committee, a neighborhood group, a local board with 3 members, and a shared email address. Small authority has a specific gravity, and some people, once inside it, can't feel the difference between the office they were given and the power they've started to believe they earned. The thing that ended him wasn't outrage. It wasn't a confrontation. It wasn't even the lawsuit. It was the budget line. $14,200, set aside to acquire something he had spent 2 years publicly claiming he already owned. Filed with the county. Signed in his own name. Sitting in the public record the entire time, patient as stone, waiting for someone to read carefully enough to find it. He documented his own intentions. He just didn't believe anyone was paying close enough attention to notice. That's the real lesson here. Not about HOA law, not about property records, not even about patience. It's about what happens when someone with a small amount of power assumes the people around them are too tired, too intimidated, or too uninformed to read the fine print. Sometimes they're right. And sometimes the person they chose to underestimate has spent 17 years doing nothing but reading fine print. The protagonist in this story didn't win because they were louder or angrier or more aggressive. They won because they understood something most people don't fully believe until they see it proven. That truth, documented carefully and presented at the right moment, is more durable than any social pressure, any letterhead, any laminated sign on a chain. You don't always have to stop someone who is building a case against themselves. Sometimes the most powerful thing you can do is keep the records clean and let them finish. So I'll leave you with this. If someone in your life has ever used a small amount of authority like it was absolute, at work, in a neighborhood, in any community you were part of, and you stayed quiet because it felt easier, or because you weren't sure you had standing, or because you thought patience looked too much like surrender, when does keeping the peace stop being patience and start becoming permission?